Good to have you with us in the 8 p.m. edition of the Urban Debate. The story we're going to talk about tonight to begin with here is the big decision by the court to reject the bail plea of Aryan Khan. The bail plea was rejected by the special NDPS court of not just Aryan Khan but also Arbaaz Merchant and Munmun Dhamecha, all three of them. The court in its order has given details of why it has rejected the bail for the three accused. So while there is obviously everybody who has a view on why this story is important or not important and why he should be in jail, is this selective targeting or not, what is going on, here are the matters in actual legal terms. Here is what the court has said in its order, why it believes that Aryan, along with the other accused, cannot be let out on bail right now. The court says the accused disclosed that they had contraband for consumption and enjoyment and that Aryan had knowledge of the contraband, the drug, being concealed by Arbaaz. And that because he knew that Arbaaz, who was with him, had these drugs on him, by that link, he was too in conscious possession of the drugs. The court has also relied on the WhatsApp chats and says that the WhatsApp chats show that there was a link between Aryan with the suppliers and the peddlers, and that is what needs to be investigated. And that the 8 people who were arrested on the cruise, when the NCB got there to conduct a raid, these people were found with a certain contraband. And so the accused acted in conspiracy with each other. They're all connected, hence they're all the same. The court then went on to say, prima facie, there appears that there is conspiracy and abetment, and that there is material available to indicate that the accused was part of a larger network, that each of the accused really can't just be seen in isolation. You have to see them as a collective. Now, these were the highlights of the order. So Aryan will continue to be in jail for now. Of course, he has an option of appealing to a higher court, and his team is already at it. The Bombay High Court at some point will take it up. But let's look at the arguments, the key arguments that were made by Aryan Khan in his defense while he was seeking this bail. The biggest argument that has been spoken about repeatedly in the courtroom is how there were no drugs found on Aryan. He himself was not carrying any drugs that were found on him. But the court says that he knew that Arbaaz Merchant, who was with him, had drugs on him. And so there is a linkage there. And that's the term that the court has used, of conscious possession. Aryan Khan's other big argument is that I didn't even know that others had drugs on them. The court says, well, there was an admission in the voluntary statement. There was initially there was a voluntary statement given by these youngsters to the NCB, later on withdrawn by their legal team. But the court has mentioned that. Aryan in court said that you should not look at all of us as a collective, that the sins of others can't be put on me if you haven't found me in the wrong. But the court says, since all of you were together, you're all liable, you're all part of a larger collective conspiracy. The one argument that was also made multiple times is that Aryan has no past history, no antecedents. But the court has relied on WhatsApp chats over there and said that the chats show that he regularly was dealing in drug-related activities. And so, basis all of this, they have found grounds under Section 29 and 37, the two key sections that repeatedly get discussed of the NDPS Act. And that is why Aryan cannot be let out of jail right now, this court believes. We have legal experts, we have experts of the law of this NCB joining us this evening to help us understand this entire case and the order and the way forward, and also cut through the clutter. For everybody who says, well, he's being targeted, well, maybe the courts are being tougher on him, or the NCB is being tougher on him because he is a celebrity and a celebrity's kid. All of this aside, we will look at what has happened and if it could have gone any other way. Justice B.A. Khan, former Chief Justice of the Jammu and Kashmir High Court, with me this evening. Kailash Vasudev, Senior Advocate with the Supreme Court. Deshratha Nigam, lawyer with the Supreme Court. Aniket Nikam, criminal lawyer, joins us this evening. I also have Najib Shah, former DG of DRI, and M.N. Singh, former Mumbai Police Commissioner, joining me this evening. Let me first go across to Justice Khan. And Justice Khan, because we had a conversation a few days ago. And a part of that was also about how often we see that the lower courts do not, in such cases, follow the norm of bail is a norm, not jail. Today, as you read this order and the grounds that the court has put out there, what is your view?
Ma'am, fortunately, we are having a court system in this country, and we are governed by the rule of law under the Constitution. A court's judgment is a court's judgment. One may have a different view of it. Some may feel that it's a harassment. Some may say that it is targeting. But court's judgment is court's judgment. Our system trusts the judge to make a judgment, howsoever trash it may be. So our system also has a very beautiful mechanism of checks and balances. If a judge goes wrong, if his judgment is trash, then the only remedy is that the aggrieved person has to go in and appeal. An appeal is provided as a remedy. And in that appeal, he can raise all those issues in which judge has gone wrong. But for me, who belongs to the judiciary, it's not for me to say that where judge has gone wrong, where judge has not gone wrong. There's no record before me that judge had the benefit of having all the record before him. And if he has prima facie returned certain findings and recorded a satisfaction that the accused does not deserve a bail, that's the end of it.
Right.
I mean, you can't dispute that judgment, howsoever different view you may have. And if any different view is to be taken, or if any loopholes are to be pointed out in the judgment, it's only in a remedy of appeal before a Supreme Court. So therefore, this time...
Right. No, I understand what you're saying, Justice Khan.
Yeah, it's all right that bail not jail is the norm. It's all right to say all that. But when it comes to practicalities, when it comes to what is before you, and you have to derive a satisfaction, that satisfaction is always a subjective, individual satisfaction.
Yes.
Objective satisfaction may be or may not be. And that's the end of it, and we should respect that and have it, those who feel aggrieved of it must have it set aside in the appeal. That's all about it.
Okay, fair enough. Now, but I just want to highlight one aspect and ask you on that before I go to our other panelists. This bail and not jail, which is said to be the norm, and there were several Supreme Court orders that also highlight that part. Does it overarchingly also apply on NDPS as an act? It is supposed to be a more stringent and a tougher act, and the conditions for bail are also supposed to be very different.
Ma'am, the bail jurisprudence has undergone a change, a lot of change. So has the view on the human rights and the right of liberty. In good old days, we used to be oversensitive about human liberty. And I remember those days when we were asked to stop all work and look into the habeas corpus petition filed by a person who had been detained. But over the years, the whole concept has changed. Today, don't you see that a habeas corpus petition is tossed from here to there and from this date to that date, and 6 months are given for filing, reply, rejoinder, this and that. So that concern, that sensitivity has by and large. Number two, the high-sounding doctrines laid down by the superior courts do not percolate down at all. Where do they percolate down? Same liberty, concept of liberty, courts must follow that. Now this subordinate court, call it a district court or a sessions court. He is a human being. He has to derive a satisfaction out of a material. What does he do with a house-ending principle of bail not jail, jail not bail? Now, if he comes to a conclusion, a fair conclusion, in his view, he is answerable to his conscience. He is accountable to the rights of the accused. If keeping in view all that, he comes to an honest conclusion that no, it doesn't deserve. That's all about it. Now, as far as whether it applies, those principles apply to narcotics cases or not, if you see the history of the narcotic cases, in that both the parliament and the courts, because of this menace which is affecting the society, have taken a very stringent view of the matter, whether it's a narcotic convictions and sentencing, whether it's a narcotic bail. And that's why the law provides in Section 37 that it is the accused who has to prove prima facie that he is not guilty, which is something going contrary to the criminal jurisprudence otherwise.
Right.
So all things considered, I still again say that it's a human element. Just as I told you in the last meeting that we have judges of different categories.
Yes.
Now, one category may be liberal, one may be conservative, one may be convicting, one may not be convicting. It all depends on him. Now, the view he takes is final. So me or the public or the lawyer has his own argument. It doesn't prevail. It is the judge who prevails.
Okay.
That's what I'm saying in our system.
Fair enough, Justice Khan. It is the individual who presides on it and how he sees it and whether he is convinced or not, or what are the arguments and the evidence presented to him. For bail under the NDPS Act, there must exist reasonable grounds to believe that the accused, that the person is not guilty, and reasonable grounds that the person is not likely to commit any offence on bail. For example, in this case, the court says, well, I cannot say that he isn't guilty, neither can I believe that if he gets out, he will not again consume drugs, because his WhatsApp chat history indicates that he has been in conversation and in some kind of a regular drug activity scenario. So, Mr. Kailash Vastev, because the immediate reaction in stories like this is to turn around and say, oh wait, this is just selective nature. They're just going after him. NCB is going after Aryan Khan because of who his father is. But this is the law. And these are the grounds that are there for bail, which a judge will have to consider basis what he has in front of him.
Good evening. See, Justice Khan has summarized it in the sense that the judge has taken a decision. I don't want to go into the correctness or otherwise of the decision, because that's a matter which will be decided in minutes, and whatever circumstances prevail, whatever the persons who have not been granted bail decide to do in an appellate court or in a higher court, because they can invoke the same jurisdictions. One very important aspect which is now coming to fore is this. The NDPS Act was enacted to curb drugs. The essential purpose of the Act is to go after those who are dealers in drugs in a big way. If you see the charges against these 8, 10 or 15 youngsters, 2 grams, 3 grams, 5 grams, charas, cocaine, etc. Most of it is, as I see it from the order, it is charas and hashish. Now, that comes into a separate category, but bail is now being amended in 88 under Section 37. Look at it on the flip side. Every day the press reports so many kilos of heroin have been picked up. So many 1,000 kilos have been picked up from a particular port, 2,888 kilograms, worth a couple of, God knows, more money than I think anyone can imagine to be having in their pocket. You have allegations coming every day, trans-border heroin transportation. You have allegations or newspaper coverages that there are huge amounts of narcotics which are available in various states. Now, the question which I want to pose before this August panel and before all the people of our country is, where are we driving ourselves? We are catching hold of people who are infinitesimally small. We are not doing anything to get the bigger rackets and the bigger drug dealers in this picture. There have been allegations against ministers in the Punjab. There have been allegations against, I don't know, I don't want to take names on the show, but the fact is, we all know that there have been massive drug rackets and cartels operating in the country for many years. I am not aware of any major arrests being made or major convictions coming through, especially for chemical drugs, which are methamphetamine, heroin, cocaine. There is going to be some kind of an origin. You have a huge government machinery to go into this and inquire. Why aren't we taking steps in that direction? Why aren't we trying to get into a situation where drugs are controlled? We are not a country like the Latin American countries where the drug cartels control the government. In Venezuela, Colombia, Honduras, it is the drug cartels which run the government. Here we have a democratically elected government which professes the principle of good governance. You have a massive, a very large force which comes in for the purposes of drug control. Why aren't we doing that? Why aren't we possibly applying ourselves in a direction to prevent this menace rather than catching hold of those people who are absolutely minor consumers? 2 grams, 3 grams, 5 grams, all right. They are users. They have a special class under the Act, under Section 27. 37 amended say you won't give them bail, but the fact is you give them a lesser sentence of 6 months to a year, maybe 3 years. So therefore, my approach to this whole situation as we are seeing it now, and it is now, see the Rajput case, Riya Chakravarti. You see what happened to her brother. Now with these kind of situations happening, where you're keeping these youngsters in custody, where you are prosecuting them or seeking to prosecute them, saying there's an international cartel involved, there is messages involved as we see in the bail order. But then catch the international cartels. You've got a connection. If he has told you that there is a person who is internationally available, why haven't you brought him before it? One of the accused has supplied a couple of grams of charas. Accused number 9 has given some couple of grams of charas to somebody. You've picked him up. But what about heroin? What about the chemical drugs? Where are you finding an answer to that?
Okay, you have raised a larger point that often is also, debated and discussed to say where are we not looking at the larger picture? We are only focusing on, few headline grabber celebrities with a few grams of this drug or that drug, but not going after the actual drug lords who are bringing in thousands of kgs of this drug into the system.
What is interesting is...
If I may just, Mr. Vasudev...
Just for a moment, I want to... Khan Sahib, if you are aware, at one point of time, there were allegations that kilos and kilos of the stuff was destroyed in police custody. Chuhe kha gaye, if you recall. Now, if goods which have been seized for the purposes of a trial are deemed to have been eaten by rats, isn't our system also being eaten by rats?
Kailaji, I was the chairman of the coffee posa.
I know, sir. That's why I'm asking you.
Okay.
And in that, I have seen whatever was seized, what happened to that.
Correct. So that is what my question is.
How it has been.
That is what my question is. The wider question.
I have gentlemen who are on this panel, and shortly I'll also have a former DG of the NCB, Mr. Vasudev, and we will definitely ask him these larger questions. But let me also go across to Aniket Nikam, criminal lawyer. Even in this case, Aniket, the court has relied on the Riya Chakrabarti case and even her brother Shouvik Chakrabarti's case, and what happened in Shouvik's case, what the judge ruled then while deciding on bail. So it seems this is now, it seems to be the new norm, even in such arrests where you may not have large-scale quantity of drugs on you, but you can still be in jail.
Well, Tanvi, the first thing that we need to understand is that NDPS Act is a special statute, and Section 37, which you quoted some time back, makes bail difficult when the quantity that is found with the accused is commercial in nature, which means that it is large amount of quantity. Now, in this case, these accused people were not found with any large quantity, no commercial quantity at all. So there is no reason why rigors of Section 37 would be invoked. And we have to also remember and understand that NDPS Act being a special statute, it envisages severe punishments for drug traffickers. However, it also envisages reformative approach towards addicts. Now, if these people, if I may call them for a moment, if they say that they are addicts or somebody who's been regularly consuming drugs, the Act itself envisages that we must take a reformative approach. Now, instead of doing that, when we start debating over issues as to now his bail has been denied and he should not be granted bail because he is somebody who has got international linkage, what signal are we sending out to the society at large? That's number one. Number two, is it not against the spirit of the act itself, which envisages that for purpose of edicts, we must have a reformative approach? And thirdly, when the rigors of Section 37 prima facie are not applicable to this act, then why should the principle of bail and not jail should kick in? Now, of course, the Honorable Court has given its verdict. They have an opportunity to appeal this before the higher forum, which they are doing, and it will be tested, the validity of this order. However, the fact remains that even in past, NCB had summoned certain people, including Bollywood actresses like Deepika Padukone, Shraddha Kapoor, on the basis of their WhatsApp conversation. However, no coercive action was taken against them. But in case of these people, these accused who are arrested now, the NCB itself is heavily relying upon this WhatsApp conversation to show their involvement. Let me also tell you, Tanvi, that the law is that these WhatsApp conversations are not a substantive piece of evidence. Yes. Now, there has to be corroborative piece of evidence, and there are senior lawyers on the panel. I suppose they would agree with me that there has to be corroborative piece of evidence in order to substantiate this piece of evidence, which itself inherently is a weak piece of evidence. Now, on the basis of a weak piece of evidence, the question remains is how far can you deny bail to a man or to these accused people?
Okay, Mr. Deshratan Nigam, before I bring in Najib Shah, would you want to weigh in on this aspect as well? Section 37 that is repeatedly was discussed, argued upon in the courts, and also now in this order we find it mentioned.
In fact, if you look at the order, it is a preliminary stage. Everybody seems to be, giving an opinion based as if the trial is complete and he has been found guilty. No, that's not the case. We have to give an opinion out here on the basis of prima facie evidence which is available. It is not a statement by the court about the guilt of a person. That has to be proven after the trial, after cross-examination and examination of various witnesses and the appreciation of the evidence on record. So that will come at a later stage. As of now, the court, on the basis of Section 37, has found that they had a common intent of drugs consumption. There has been a regular procurement and larger international nexus that has to be emerged. Then there are WhatsApp chats. It's an electronic evidence, and amendments have been made in the Evidence Act to admission of electronic evidence. So obviously corroborative evidence would be required and investigation is going on. So prima facie, as of now, without commenting on the guilt of a person or not being guilty, I am of the opinion that the court was bound to strictly look into the law as it is available. And Supreme Court, in the case of, let me remind you, as I quoted last time also, that is the case of Bharat Thakur versus State of Maharashtra, where they have clearly said under the NDPS, bail has to be given in rarest of rare cases. So ordinary criminal jurisprudence has been changed out here. So, and also the law where the accused has been given the burden of proving his innocence, that he is guilty till proven innocence and the burden lies on him. So there has been a change of law from ordinary criminal jurisprudence. So at this stage, and the court also noticed there is a considering possibility of tampering of evidence. So all these taking into the basket of facts which is available, not proven yet, I'm again repeating, not proven yet, prima facie, it cannot be said, as the court said, he is not guilty of the offense, and it also cannot be said that he cannot commit the crime again.
Okay.
So therefore, it is an issue of bail right now under the NDPS. Again, I am reiterating, it has to be in rarest of rare cases. And I, as a lawyer, cannot, come to a conclusion about the guilt of a person or not.
No, okay, fair enough. But the point that Aniket was making, and Mr. Nika, I know you wanted to come in, but if you could just give me, a couple of minutes, let Mr. Najib Shah also make his opening remarks, and I'll come back to you. Mr. Shah, the point that was being made is that Section 37 and the stringent sections of that are to be used when you find large, amount of drugs, large quantity of drugs on somebody, or rather, in a larger scheme of things, the tough part of this NDPS Act is to crack down on that kind of a network, the larger drug network, and not possibly for, if there are consumers of a little bit of a couple of grams of drugs on them.
Well, my learned panelists have spoken very eloquently about the provisions of the law itself. Let us for a minute just grant NCB the benefit of the doubt that they are indeed a professional organization who know what they are doing, who have built up a case of some contraband having been recovered not from the gentleman about whom we are discussing. There are other people also in this case, and further investigations are required. As has been brought out repeatedly, Section 37 is a very stringent provision. It is cognizable, non-bailable provision, which specifies the condition for which the court can give bail. Obviously, the learned magistrate in this case.
My apologies to you, but the network with the connectivity with you is really bad, and we are struggling to just understand your point. So we're going to try and repatch that. Meanwhile, Aniket can make his points. Go ahead.
What Mr. Nigam said, that at the stage of bail, one need not comment on the guilt or innocence of an accused, that's completely right. But at the same time, the question is that why do you need the custody of a man after his police custody, in this case, NCB custody is over, and there is absolutely nothing that he is required to remain behind bars for. Now, this is not a case of consumption. This is not a case of possession. This is not a case of commercial quantity. The case is based primarily on WhatsApp chat. It has also been argued on behalf of NCB that he's a part of the conspiracy. But let me tell you, in order to be part of a conspiracy, it is very important for them to show that he was aware of the end objective of this conspiracy. Now, what was that end objective of the conspiracy? That perhaps they have not stated anywhere, number one. Number two, what my learned friend Mr. Nigam had argued, that Bharat Thakur's case, it is mentioned by the Supreme Court that bail has to be granted in exceptional circumstances, but that was a case of commercial quantity. Now, this is not a case of commercial quantity. One can really make a difference between cases where the contraband that is involved is huge in nature, or in the cases where the contraband that is involved is small in nature. Now, this is a case where Mr. Khan was not even found with any contraband. It is not even their case that he consumed any contraband, and that is the precise reason why they did not even did his blood report. So all these circumstances will have to be looked into. And as I said earlier, NDPS Act is meant for the purpose of reformation as far as consumers are concerned. I'm not saying he's a consumer, but even if their case is taken at its best, that he is involved and he is involved in consumption, then we need to have a reformative outlook as far as such kind of people are concerned.
Can I come in?
Yes, Deshratan Nigam.
See, anybody, saying that this is stage reform or not, this is finally you have to decide how much quantum is found guilty, that person needs to be reformed. Not at the stage when he is not even found to be guilty. Reformation is of a person who has been found guilty. Therefore, at this stage, the question of reformation would not arise at this stage of the bail. You want to reform a criminal. He's not a criminal. Let us make it very clear. He's accused of crime.
No, you have misunderstood what I'm trying to say.
Yeah, I don't think, Mr. Nigam, that's what he was saying. I think he was talking largely about what the Act is supposed to do.
The purpose of the Act.
Yes, the purpose of the Act.
If you read the statement of objects and reasons of the Act.
I know, I'm aware of it. Please allow me to complete.
Yes, sir.
The fact that reformation does not arise at this stage of the bail. Bail is about investigation, unearthing the facts, larger international conspiracy. And they have also said in the order, considering the possibility of tampering with the evidence, the possibility, and therefore they have rejected that bail. So therefore, reformation is a subsequent stage. It is not to come at the stage of investigation. He is not even guilty, pronounced guilty. So how can you bring in all those reforms at this stage? I'm saying he's not involved into anything, but prima facie right now, there is an opinion held by the court, and reformation will not come at this stage at all.
Okay, so I wanted to raise a couple of points. And again, my intention here, via the legal experts who are sitting with me tonight, is to possibly find answers to what everybody is sitting and discussing right now. Let's be honest, it is, whether you like it or not, this is the point of the conversation tonight. One of the aspects which Aniket Nikam also referred to, Mr. Kailash Vasudev, was that there was not even a medical test or a blood test done at that point when he was picked up to check whether he had consumed drugs. Now, while that point is getting repeatedly raised, is that something that a court will look at while deciding on the bail part of it?
As a matter of fact, this is something the court should have looked at. But as I said, I don't want to comment on the bail because that's a decision taken. Whatever they decide to do in the superior court, they will do. But one interesting point which I wanted to talk to Mr. Nigam about was, Mr. Nigam Senior, not you, Aniket. He says that this is not a stage to decide the state of whether a person is guilty or not guilty or the like. Essentially, the Act says you are guilty till proved innocent. It is now for the magistrate to sift through the evidence, or the district judge to sift through the evidence to see what kind of a seizure is there. Section 27 has to be read in conjunction with 37. You have now reduced the rigor of 27 by amending 37 in 1988 by saying this is a non-bailable offence. But if it is not a commercial quantity, now look at the flip side. You've kept all sorts of people in custody, Chakravarti family, the Delhi rave cases, all youngsters below the age of 25, wanting to experiment with drugs in their own way, thinking they'll have a good time. Now you have kept them in custody and eventually release them on bail. The trials in those cases are yet to start. Can you imagine what damage you're doing to their reputations when they're acquitted tomorrow? If it is proved in due course of time that this was only a one-off, or it was an occasion where these youngsters decided to do things together in tandem, maybe in violation of the law, but it was not an offense of a commercial nature. You have destroyed their reputations for life. You have no restitution which you will give them. Please think, a criminal case being slammed onto somebody being held in custody. Riya Chakravarti has not been able to get an appropriate engagement after she was released from jail, and she was an actress of good standing. Her brother has been damned all the way through. So you see, the purpose of the act should not be one where you're going to destroy somebody before a trial. If you're in so much of a hurry to convict them, finish the trial in 3 months, I challenge you. No NDPS trial is finished for years together because you bring in hundreds of witnesses. Here you're thinking of an international conspiracy. Where will you get the witnesses from? You will be hunting for them and you'll be taking court's time and so on and so forth. Both the Nigam, Senior Nigam and Mr. Junior Nigam, if I may use the words, are here. How much time does an NDPS case finish?
If I may just, Mr. Kailash Vasudev, point out though, he's Aniket Nikam, so
not Nigam.
Not
Nigam, but I'm sorry, but I'm just trying to put them together. But the fact of the matter is that none of these trials finish for years. You keep the people hanging. What is the consequence when they are acquitted eventually? You see, these are elements which we must consider in the judicial system also. Our judiciary must wake up to this.
Yeah, in fact, if I may add to that, Mr. Kailash Vasudev, to the point that you made, there is also an argument there when we say that, okay, all the, all the views, liberal views about human rights that the Supreme Court talks about, often if you will allow me to finish this point, even the High Courts implement when they say, bail and not jail, doesn't percolate to the lower courts. Now, the likes of a top journalist in this country or a top actor's son have the wherewithal to at least go to the High Court and go to the Supreme Court and seek, relief from them. What about the others who will just continue to rot in jail because bail isn't granted at the lower court level?
You see, I just want to come in here before you hand it over. There are cases which are pending in court. I was doing some bit of research, including some of the cases we've handled. Small people who deal on, who sell vegetables. There's cases from Uttarakhand where this man was selling small amounts of drugs once in a while just to make an end meet because of the pandemic. He's been in jail now for 18 months. bail has not been granted to him, his family has gone to penury. There are so many such instances you will find that people have taken to this for a different purpose. They're not selling commercial quantities, but on the other side, you're not trying them.
Right.
They're small peddlers. You've got the man who's doing it. Why don't you go for the cartel which supplied the goods to him? What stops you? Corruption? Money? The ability to buy your way through? Is that what our prosecution is doing today? I'm sorry, but I feel very strongly about this.
No, I understand, and I can sense that, you know, in the way you're speaking this evening. But just if you'll allow me, I think Mr. Shah is back with us, and we're going to try and see if we can hear him better, Mr. Najib Shah. The last time this question that Kailash Vasudev is raising today was raised as to what happens to the larger crackdown. We had experts who told us, but that happens. Usually, maybe the media doesn't report about it. Would you want to, you know, shed some light on the extent of the drug cartel crackdown that happens or doesn't happen in our country?
Look, I'm audible, please.
Yes, you are.
Okay. The panelists have been speaking very eloquently about, in effect, casting aspersions on the quality of the investigation itself. Let us, for a minute, give the Narcotics Control Bureau the benefit of the doubt. They are indeed investigating something. You can attack the problem of drugs either from the supply side, and I must remind the panelists and you that the Directorate of Revenue Intelligence Reform Organization has made outstanding cases. We have made 3 tons of seizure recently from a private court. In Bombay, we have had seizures of 25 kgs of heroin just a couple of days back. So large quantities of seizures have been made across the country, and in all probability, these could either have been used for consumption within the country, or India also is a transit point because of the geographical location. Now, on the larger point itself being raised by my learned friend about the fact that small timers get detained in jail for long periods of time, don't blame the enforcement agencies for that. It is a judicial process which has failed us ultimately. And in this case, it will be unfair to place the burden on the enforcement agency, which is making a suggestion that this person is involved in a case. I hold no brief for anybody here, except to say that investigation is difficult, investigation is challenging, it calls for putting together a lot of loose ends, it takes time, and yes, the NDPS Act is a particularly stringent act where I agree that the enforcement agencies need to proceed with caution simply because it is stringent. But similarly, the courts have a burden on them because it is stringent to ensure that bail is not granted routinely. Section 37 is a cumbersome section. It talks of it being cognizable, non-bailable. We have decisions of the Supreme Court which go on to say that recovery is not required for denial of bail. So you have even those sort of situations there. So I believe that we should let the investigation process go, and the gentleman, if he has to get bail, if the court decides that he has to get bail, so be it. I don't think the NCB should contest that because their investigation should not get tampered, which should be their primary concern. Okay,
Mr. Kailash Vasudev wanted to come in.
Mr. Shah, I agree with you that this is a very difficult area to investigate because drug cartels are not easy to come by. But on the other side, with your huge machinery available to you, you are now in a position to find out where all the drugs are available. You say investigations take time because you have to approach it with caution. But where this conviction in such cases under 27 is limited to 1 year, and you are following the judgment of the Supreme Court for not granting bail in such cases, please understand those judgments are in huge commercial seizures, they're not in small seizures. Now, if you're going to take the view that your investigation through the narcotics control system is going to take time, you have got these youngsters in custody with a maximum conviction of 1 year, maybe 3. What are the chances that these youngsters would be able to do something in life after they're released from here? Either you expedite, you're blaming the courts will wait for you to lead evidence. Till you don't lead evidence, the court can't proceed. So it becomes a catch-22 situation for an accused. You blame the judiciary asks you, you have no answers because you say you will take time. Where is there a system of justice for those who are here for short sentences? I can understand big cartel cases, 10 years, 20 years, we will tackle it. But what about these youngsters? Till you don't finish investigations, they have no remedy available to them, excepting stay in jail. And then when they come out, they are rude. They are told you're drug peddlers. Their reputations are over. Please look at it on a holistic pattern. If Mr. Nikam has raised the issue of reformation, reformation comes the first step in such cases. It's not the last step.
Well, if on the point of reformation, Justice Khan, even the NCB, made an argument in court to say, well, we also have to send a message to other youngsters because this has become a big drug menace amongst the youth. Now, to your mind, does that argument work that the Anti-Narcotics Bureau is saying, let's jail a couple of these guys, obviously the famous ones and the celebrities, such that everybody else gets the message that if you try to consume drugs at the age of 16 or 21, this could happen to you?
Tanvi, it's open for lawyers to argue this way or that way and to raise issues which should be raised in a public domain. But it's not for me being a judge. I have served judge for 20 years. I can't adopt those pleas which they are taking. Everybody has their own view of a fact situation, for example. But as I said, the system is that it is the judge's view which prevails. Now, as far as this young lawyer was arguing about some reformative approach, Kailaji was asking about restitution, no provision for restitution. Now, these are issues which fall within a very wider debate. And these are issues which are not for the judiciary to tackle. For example, if a reformative approach is to be adopted, there has to be a policy for it, as we have in other countries. Similarly, if there is a restitution, this is not the only case where, for example, an accused is shamed. Now, we have seen cases where 20 years people have been put on trial and acquitted after 20 years.
Right.
What happened to their life? Where was that restitution?
Right. I agree with you.
This is not confined to a drug case. I don't dispute that double standards are prevailing. I don't dispute that my system, judicial system, suffers from a number of ills which I have been highlighting from time to time. But having said all that, how can I say, suppose I am tomorrow on the appellate bench and the same thing appeals to me and I render a judgment. I may have gone wrong in the eyes of this young lawyer. But that's not for a TV show to decide. That's not for the lawyer to decide. That's for a higher superior court to decide, and we have to obey by the system. And as I said, that there are checks and balances up to the Supreme Court available. Yes, a person suffers in our working. Tanvi, what can I tell you? 100 times we have said this criminal justice system is in shambles. Is it not in shambles? Same, do you know what does it investigation? This is a shoddy investigation taking place from case to case. Is there a proper scientific fair investigation we are having? Are we not having a lazy and lethargic judging? Same thing, Tariq pe Tariq, which I was telling you last time. Is it not a fact that the same prosecution will not procure witnesses for years and years on and subject the accused to a torture for life? Now, these are all problems which are afflicting our judicial system. And the more we have been speaking about it, the less there has been a reform.
Well, I would allow me to admit, Justice Khan, that perhaps all of these conversations just get limited to TV debates and nothing really changes on ground. The fact that there are some overhauling of the criminal justice system, right from the investigative authorities to the prosecution and the judiciary. Yes, but the changes, I don't know who will bring about that change. Let me also say good evening to Mr. B.V. Kumar joining us right now. Mr. B.V. Kumar, I don't know if you managed to catch, I didn't know if you managed to catch the first half of our conversation, but Mr. Kailash Vasudev here was very passionately raising the issue of, targeting perhaps, or going after and spending a lot more time after consumers of small-scale quantity of drugs rather than the authorities cracking down on the large drug cartels. If that is where the focus of the authorities and the NDPS Act should really be.
Yeah, I fully agree with you. NCB was initiated and started in 1985, and the agency was started basically to tackle drug cartels operating within India and outside India also. And for that purpose, a convention is there where international agencies do cooperate in investigation into major drug cartel cases. And it's the job of the Antinarcotics Control Bureau to investigate such major cases. That is the object with which it was started. The law also is quite lenient as far as the drug users are concerned, and they are supposed to be rehabilitated once they give a sort of a bond to the Honorable Court and also agree to undergo treatment to a recognized government hospital or an institution which is recognized by the government. That's the whole object. But in this particular case, the learned judge has given various reasons, depending, and he cites the Shovik Chakrabarti's case. And he says, when there is a conspiracy angle that has been cited in the proceedings, he says, since accused are part of the conspiracy, each of them is liable for the entire quantity of drugs seized. The case of each accused cannot be segregated from each other and cannot be considered in isolation. That's what he observes. And prima facie also relies upon the evidence that has been cited in the WhatsApp chats. But to what extent those chats reveal is a matter of judgment which the Honorable Judge relies upon. And he, on that basis, prima facie, he denies the bail. So at this stage, we cannot question whether the granting of bail is right or wrong, since the culpable mental state of the accused is involved, number one. And number two, the provisions of the NDPS Act override the provisions of the CRPC, particularly Section 439 of the Criminal Procedure Code. That being so, I think the judge at the prima facie, he believes that the accused may tamper with the witnesses if they are set at liberty. He also mentions further in the order very detailed reasons as to why the bail cannot be granted at this stage. But I'm very sure the Honorable High Court of Bombay will take into consideration all these pleas that have been put forward for the release of Aryan and his colleagues. I personally feel it would have been fair, taking into consideration all aspects of the case, if the Honorable Judge has, it's not for me to comment on the judgment itself, right, but it's my personal feeling that he could have granted 15 days further custody and given a direction to the accused, the Narcotics Control Bureau, to complete the investigation and put forward all the evidence so that the charges can be framed and the trial can proceed. That would have been a fair approach in this particular case. I'm very sure the Bombay High Court will take into consideration all these aspects.
Okay, thank you so much for that. You know, one aspect that I wanted the lawyers to also talk about, and Mr. Deshratan Nigam, I'm actually coming to you on this because I want to explain this to our viewers as well. The concept of seeing all 8 accused as a collective and saying that it doesn't matter whether you had the drugs physically on you, but because you're all part of this conspiracy, it will be considered that you were all found with these drugs. Secondly, in Aryan's case, if you knew that your friend was carrying drugs, was carrying charas of whatever grams, and so because you knew about it and you were there is a concept of conscious possession that has been also mentioned in this order. What does this mean, Mr. Nigam, if you had to simply decode this? Does this mean that if I go to a gathering where certain other people may have, I'm not saying this happened in Aryan's case, I'm saying, but there may be other people who are carrying drugs, consuming drugs, and I could get into trouble for that?
Tanvi, let me first answer some of the statements made by the panelists. They were talking about judicial reforms. Yes, nobody denies that there should be judicial reforms and the trial should finish as quickly as possible. I don't think anybody would have a dispute with that kind of scenario. And secondly, 27A also talks about, drug trafficking, procuring, and financing as well. And therefore, 27A does not talk about merely commercial quantity. Now, thirdly, let me give you an example. If you are in a group and one person is carrying the drug and you are a part of that group, then it would be presumed that you are also in conscious possession of it, because that person can use it for others as well. Only one person carrying does not mean the other person will not use it. Hence, it is a concept of conscious possession. And however, at the same time, without commenting on the merits or demerits of Aryan's case, we are at a stage where drug is a huge menace in this country. 3,000 kg was found just at the entrance of the international border of the coast of Gujarat, which is about 21 to 25,000 crores, which people are saying that it is linked to narco-terrorism. The issues are serious. And when you talk of the big fish players, the chain starts from the top to the bottom or from bottom to the top, from consumers. So the issue of larger international access and conspiracy is becoming quite important here based on the WhatsApp chat. This is the prima facie opinion, and it has to be further dug into and found out of whether these can be taken to logical conclusion through investigation. So at this stage, the larger picture has to be taken into consideration, and individuals have not to be considered in isolation, since a conspiracy issue is also involved. So,
but let me, and I am purely asking this question from a layman's point of view. And Mr. B.V. Kumar, if I can bring that aspect back to you, to say that we need to look at the larger picture and not just the individuals in a setup where you're talking about, youngsters consuming charas. Some of them may be, some of them may not be, we don't know. But we have collectively seen this as a conspiracy and used the law, which is supposed to actually enable you to go after the larger drug cartels, the suppliers, the smugglers, the ones who are targeting these youngsters, the ones who are, taking it to every nook and corner of our big cities and little towns and our educational institutions and everywhere else and targeting these people. If you say there that I see you as a collective and I see, all of you together as the ones responsible, I understand. But does it apply to even people accused of consumption?
Not necessarily, but we should also remember that a demand supply will start only when there is a demand. Now, if you see the extent of drug abuse in the country, for example, in 2004, it was about 2 million people. In 2018-19, it rose to 22 million. God knows how many people are consuming now. With the increase in supply, tremendous amount of quantities of cocaine, apart from heroin, are being smuggled into the country. In the last few months, hundreds of kilos of drugs have been seized. At Mundra, you've seen that almost 3 tons of cocaine was seized. Heroin was seized. And earlier to that, in Tuticorin port, 300 kilos of cocaine was seized in a container set to contain logs. Another Sri Lankan vessel was also seized with about 300 kgs of cocaine, with AK-47 rifles and about 1,000 rounds of ammunition. And even day before yesterday at Cochin airport, 2 African women were apprehended with 503 grams of cocaine. So you can see the shift in the type of consumption that is happening. That is from the opioids, drugs like hashish or heroin. They're shifting to synthetic drugs like cocaine, and we are shifting to MDMA, the ecstasy pills, and so on and so forth. Then what will happen is, in the case of cocaine, you have to inject it into the body of the abuser. Then if there is no change of the needle, it will lead to HIV infections. These are the serious problems which the country is going to face. So we have to tackle both on the supply side, as pointed out rightly by my learned panelists, and so also on the demand side. But that doesn't mean that we have to make examples out of simple drug abusers who take probably for a first time or for a series of time because they become chemically dependent. That's the unfortunate part of each one of the drugs. So if they become chemically dependent, unless they go through a treatment procedure, they will not be able to come out. And in 3 years' time, they will die. That's the unfortunate part of it. It affects the small brain that is the cerebellum, and it leads to the destruction of hunger. The hunger will not be there, and they will not be able to have any sex. Once that is there, in three years' time, they will die due to anemia, and they will have no resistance for any infection. That's the dangerous part. So we have to tackle both on the demand side as well as the supply side. I have also suggested that we have to bring about a change in the syllabus of certain courses. For example, in medicine, in nursing, then in the case of law students, and so also other faculties where through the education, they can be influenced about the after effects of drugs and other things.
Yes, and as drugs become more and more easily available, accessible, and there is targeted distribution and selling, I think that is the bigger menace that we all should be spending a lot more time discussing, highlighting and talking about, and of course the authorities cracking down on that. Completely out of time. I'm going to thank all of the panelists for joining us on this conversation, but that should be the larger issue to focus on. And you just heard from Mr. B.V. Kumar, who listed out all of these examples. You may have missed the news, the big news about 3,000 kg of heroin being seized, but it was. And then there were significant follow-ups to that, with the NIA coming in, raids being carried out all the way from Gujarat to the national capital. The crackdown on that continues. Obviously, we are not doing enough. And you and I know that because everybody knows still how easily several of these extremely dangerous substances are very, very easily available, at least in the biggest of our metro centers, targeting the youngsters of our country. Perhaps that is where our energies need to be put into a lot more than having a conversation about this repeatedly. Food for thought. Thank you so much for joining us on this conversation.